Good morning, everybody. Welcome to today's land law lecture. So we're on doing large group 5 now. So we'll be looking at easements today, and that's quite a big subject. So we'll be dealing with that especially with the workshop, there's 5A and 5B in terms of easements. We used to do it all in one session, but it's such a big topic that we decided to split it up into 2 sections. Okay, so I've got the attendance code and I'll leave that on the screen for a moment to allow those that haven't yet joined the session to mark their attendance. And as always, for today's session, what you should have to hand is your student guide. I'll be referring to this throughout the session today, and it just helps you to enable you to fill in the necessary details where there's gaps in the actual student guide. You can type in or handwrite the necessary information there. Okay, so last week we were looking at co-ownership, and as I say, for this week we're moving slightly away to a larger topic, and that's easements. By the end of today's session, you'll see from the outcomes that are listed at the bottom of your student guide that you should feel confident by the end of all the sessions as to how you would essentially sort of describe what's known as the essential characteristics of an easement, and we'll look at the case that defines that later. And you should be able to know the difference between an easement and a license. And you should be able to explain the different types of easements and how they're created, and to describe whether an easement is enforceable against a successor owners of the land that's burdened with the easement. Okay, so what we'll do is there is a short clip that I'm just about to play for you, and that's called looking at the essential characteristics of an easement. So just bear with me. Okay, so I'm just going to play this short clip.
Piece of land that burdens another piece of land. It can be positive, for example, a right to use land of another in a particular way. Or it can be negative, restricting the use of another's land in some way. For example, a right of light to a window that stops someone building a house that blocks the light. Have a look at the plan on the screen. Imagine that the field with the horses in is owned by Diane. The house and barn are owned by James. If James wants to use the path from the barn as a shortcut to the bus stop, he'll need an easement over Diane's land. This will be a right of way, a positive easement. Suppose Diane decides to sell her land to a developer who plans to build a high-rise block of flats right up against the fence. If this will block lights coming through James's windows, can he stop the development? Well, he might be able to if he has an easement of light through his windows. That right of light will be a negative easement. To go onto your neighbour's land, you must have an easement or a license. Otherwise, you're a trespasser. Diane could give James a license to cross her field. However, a license is a temporary permission which can be withdrawn at any time. If James wants to have a permanent shortcut, he'll need an easement. A license might be more appropriate if James's son, Ewan, asks Diane for permission to go into the field to retrieve his football. The benefit and burden of a license do not continue if the land is sold. An easement is better than a license in that it's permanent. The burden will pass to new owners of the land concerned if it's sold, and the benefit will pass to the new owners of your land if you sell it. So we can say that an easement allows you to enter another person's land as of right. A license allows you to enter it with permission.
Okay, I'll share the attendance code for those that have joined us late. All right, so hopefully you would note from the short clip that we just watched um, about what essentially is the characteristics of an easement. And this is really described essentially in a case called Re Ellenborough Park, and it sets out these 4 essential characteristics that makes a valid easement. So whenever you have an exam question and it's to do with easements and you think there's an easement that's relevant, you would always talk about Re Ellenborough Park, and you describe whether it meets the 4 essential characteristics. Okay, so I'm just going to move on to the next slide now. So the essential characteristics are outlined here on this slide. And you'll see that the first one talks about how they must be a dominant and a servient tenement. Now, these are a lot of legal terminology, I think, that most people are not used to hearing every day. So what does it mean by a tenement? So I like to think of a tenement as being sort of another word for land. And so when they say, what does it mean by dominant then? So if they say dominant tenement, what does that mean? And I think that it's probably easier to understand that as being the land that has the benefit of the easement. So if a land is able to enjoy an easement, that land would be the dominant tenement. And I guess that's true then for the opposite. So the servient tenement is the land that serves the dominant land. So it's the land that basically gives the benefit. So it serves the dominant land. Okay, so that's the first characteristic of an easement. Let's now move on to the second characteristic. So the second point on the slide there. So it says that an easement must accommodate the dominant tenement. So let's look at what this means in detail. I mean, I would think that actually the meaning of this is that it just connects with the normal enjoyment of the property. I think that's essentially what it means by accommodating the dominant tenement. So then we've got 2 more characteristics. The third one being, I'm just reading from the slide here, the dominant and servient tenement must not be owned and occupied by the same person. So I think I'm assuming that's quite straightforward, quite obvious. So if you've got 2 parcels of land, they can't be owned by the same person. Otherwise, there wouldn't be a need for an easement, I guess. The owner could just walk from one piece of land essentially to another, and he wouldn't be trespassing. So now let's look at the last characteristic, which talks about, it says here on the slide, the right over the land must be capable of forming the subject matter of the grant. And essentially, I think probably what this means is that you should be able to draft an easement as a deed. If you were asked to do that, it should be possible to do so. Okay, so we're going to examine these characteristics in greater detail now. For those of you just that have come in late, I'll just go back to the first slide so that you can mark the attendance code. Okay. So I'll move on to the third slide shortly, but what it will show is a plan of 63 and 65 Hampstead Road. Okay, so we briefly mentioned, I'm just going to go on to that third slide now so that you can see. I briefly mentioned that there must be a dominant and a servient tenement. So when we're looking at this slide, you'll see that essentially, if you could, so this is number 63. Let me just get my blue pointer. 63 here is outlined in red, and then it's got these blue dotted lines that runs along the plot 63. So one parcel of the land has the benefits of an easement, aka the dominant land, and the other has the burden of the easement, and that would be the servient land. So just for a moment, if you could just look at this slide of the plan, 63 and 65 Hampstead Road, you can see that that blue dotted line that I referred to earlier, this would be the right of way. So those blue dots represent a right of way, and it runs along the back of the two houses. I just want to do a quick poll, if I may. Let me just set up a quick poll. What I'm going to ask you to do is just to identify which you think is the dominant tenement in this situation. Just bring up the poll just to test our understanding. Okay, so you've got a 50-50 chance of getting this answer correct, I guess, because there's only two options here. So what I'm asking you to do, I've just started the poll now, is for you to identify which of those two parcels of land, which one represents the dominant tenement. Waiting for a couple more votes. So one land has the benefit of the easement. That land's usually known as the dominant tenement, and the other has the burden of the easement. It's the plot of land that has to serve the dominant tenement. Just got 4 more people to vote now. Come on, no responses. Otherwise, I'll use breakout rooms instead. I think people prefer polls rather than the breakout rooms. Okay, all right. This was just a quick quiz, so I'll just show the responses. Actually, it's quite split. However, let me just show your responses. However, in this case, the majority that said 65 Hampstead Road, you were absolutely correct. So if you look at, if I just close down this poll, if you look at plot 65, it needs to have, and I'll get my blue pointer, plot 65 here, it needs the right of way over 63. So it's the only means that they can have access to the back here. So if they wanted to go to the back of their property, they would be walking from the main road or driving through. I'm not quite sure how wide that access is, but that's the only way that they can gain access through the back to go into their property. The only other way would be here. If there's no, it doesn't look like on this side there's any other sort of right of way, because that's the boundary of another plot. So if they wanted to gain access from the back, they would need to sort of go along this path here in order to do so. So 65 has the benefit of the easement, and 63 is the servient land. It's serving plot 65. Okay, let's just change the slide. Okay, so we were looking at, let's have a look in detail at the other 3 characteristics. So we've just looked at 1, and now we're going to examine in greater detail characteristics 2, 3, and 4 that's on the slide there. We've already said essentially that the easement must accommodate the dominant land, and this means that it must connect with the normal enjoyment of the property. So it's not just to enhance the value of the dominant land or be sort of purely for personal benefit. It literally has to connect with the normal enjoyment of that property. Okay, so that's 2. 3, which talks about dominant and servient tenements, must not be owned or occupied by the same person. So we've already highlighted that you can't sort of give yourself a right of way over your own land. If the right would have been an easement to the servient sort of tenement, if it was owned by somebody else, then I guess essentially it's more or less a quasi easement. A quasi easement in sort of layman's words, or the way that I like to think of it, is a fake easement. So it's not a real easement, but if it was owned by 2 different owners, it would be an easement, if that makes sense. So don't worry about that for now, because we will examine quasi sort of easements in greater detail later. Okay, let's just move on to the next slide. Okay, so the next slide is headed here. It must be capable of forming the subject matter of the grant. So the right over land must be capable of forming the subject matter of a grant. And what this means is, the first limb of it is that you need to be what's known as a capable grantor. So that's one who has the power to basically grant it. The second limb is that you need a capable grantee. So what do you think? What do we mean by this? I guess an example would be if it said sort of all inhabitants of a village. This wouldn't be sufficient because it's just too vague. It's a fluctuating body. So in that scenario, you wouldn't be a capable grantee. Okay, and the second, so bullet point 2 there on the slide, it says that, as we more or less talked about, the right must not be too wide or too vague. So too wide is often considered for claims of right of light. So when you have parties claiming that, you know, they've got a right of light, often that claim is just too wide to count. To be valid, the easement has to be basically essentially not too wide. So if you're trying to claim a right of light, really that light should be for light that passes through a designated or particular window or skylight. And this is detailed in a very old case called Coles v Holmes and Colonial Stores Limited 1904. And it was held in that case that a right of light would only be upheld where the light being claimed was for a particular window or skylight, and not a general claim for a light over a whole piece of land. So you can't, if your neighbour is sort of building something at the back of their house, you couldn't say, oh, they're blocking my right of light for my whole garden. It would be maybe if there was a greenhouse and you needed light going in through a particular pane of window, that might be acceptable, but you couldn't just say, you know, for the overall garden, that wouldn't be acceptable there. Okay, so the third bullet point we've got says the rights must be one of utility, the benefit, not just a mere recreation. And I think this just means that it mustn't be sort of like a mere amusement, mere recreation there. And this was the prime importance when we considered the case of Re Ellenborough Park. The fact that people can wander over a piece of land doesn't stop it from being a utility and benefit, provided it's linked to a defined piece of land. Okay, so looking at this last bullet point here, so the right must not deprive the servient owner of possession. So So the right must not be inconsistent with the ownership of the servient land. It mustn't basically exclude the owner from their own land or from enjoying it. And this, if you look in your student guide, there's a case called Copeland v. Greenhalgh, 1952, and that explores that idea. It seems to me that it's a question, it's sort of one of degree. So if someone else is using land and it involves them being prevented from using their own land at all, then I guess the claim for an easement would be rejected because it would deprive the servient owner of their rights as a property owner. Okay. All right, so we're gonna do 2 MCQ questions just to aid our understanding of what we were just discussing. So let me just try and set up your next poll here. Right. There's 4 options. Okay, this time if you can all vote, otherwise we'll try the breakout rooms for the next one. Okay, so which one is not capable of forming a subject matter of a grant under the 4th condition of re Ellenborough Park? So these questions marry up with, I think it's page 4 of your student guide, activity 1. So a couple more votes. At the moment, the majority are correct. Just waiting for a few more votes. So remember, when we do the land assessment, it comprises of 2 parts. You've got 40% for MCQs, and then you've got the written part of it. So it's really good to just get used to trying to answer these sort of multiple choice questions. Couple more votes to come through, and then we'll show these. Okay, I'm going to reveal the responses now. So the majority that said 3, which marries up with C in your student guide, a right to a view, absolutely correct with that one. So a right to a view is just too wide and too vague to lie in grant. And so the best way to deal with this question, really, I would say, is to tick off those that are capable of forming the subject matter of a grant. So a right of way is clearly acceptable, because that's, you know, like the example that we looked at earlier, there was that right of way, wasn't there, from 63, or the property that was served in 65. A right of light is capable of forming a subject matter of a grant, as long as it's through a designated window, specific window or defined channel. And another case that talks about that is Allen v. Greenwood, 1980. A right to park also can meet the test, but it depends on the degree of the invasion of the servient land. So the right would not pass the test if it had an effect to leave the servient owner without a reasonable use of his land. And that was discussed in a case called London v. Blenheim Limited, v. Ladbroke Parks Limited, 1992. So London and Blenheim Limited. I should put that in the, let me write that in the chat so that you've got that. It's a 1992 case. Ladbroke Park, 1992. Lana, what was your question? Is this under right to view? I don't know what you're referring to. Is what to do with the right to view? The case that I mentioned was to do with a right to park. So, you know, one of the options for the question that we just did in the MCQs, I was just saying what was acceptable. So a right of way is acceptable. So number one is acceptable. A right of light is possible. So number two is possible, assuming or providing that it's through a defined window. And a right to park is acceptable just as long as it depends on the degree of the invasion. So the case of that I've just put in the chat was saying essentially doing that test. So if it had the effect of depriving the servient owner use of the land, then that wouldn't be classed as an easement. Is that okay, Natalia and Lana, before we move on? Okay, thank you. All right, let me just put down this poll. Okay, so let's have a look at the second question in your student guide as another MCQ, which sometimes I might have to do it as shorthand actually if the question's too long. Oh, this should fit. Okay, so the second question is, which one of the following rights may be described as a negative easement? So I'm just going to put this on the poll so that you guys can vote. So the options are a right of drainage, a right to store logs in your neighbour's shed, or a right to water from a pipe, and the last one, a right of support. So have a go, all of you, if you can, because it's the more practice you get at sort of doing these MCQs, the better you become. To find a technique, I think whittling out the obviously incorrect questions is probably the best way. And that just leaves you with perhaps one or two that you just have to make a decision as to which one's correct. Okay, so which one of the following rights may be described as a negative easement? What do we mean by negative easement? What does that mean, negative? So, okay. A couple of you got the correct answer here. Negative easement, what could that possibly mean? give you 1 minute, so when it's 9:31, and then we'll talk about what we mean by negative easements. I think this one must be tricky. Okay, not meant. Okay. Oh, it's a shame. Whoever just changed their vote moved their answer to the wrong place. All right, I'm just going to reveal your decisions now. Okay, so the correct one is a right of support is described as a negative easement. So a right of drainage, all the other ones, they're sort of positive normal easements. A right of support is negative, and I'll just explain why in a moment. So if you think about it, a right of support is, for example, like a right not to have a wall of your building undermined by your neighbour, for example, if they were excavating their land, because then what this would do is that it will affect their development of your neighbour's land. So this is sort of negative. All the others would be positive. Does that make sense? So if you think about drainage, that would be a physical pipe, wouldn't it? It would be going under someone's property. If you're storing logs on a neighbour's land, that's like a positive action. If you're trying to get water through a pipe, it was me who changed. Oh, sorry, Natalia. Never mind. If it's a right of support, you're basically, there's nothing physical that you've actually done. It's just you want to stop, I guess, your neighbour from doing something that's going to compromise your building in some way. So you know when you've got those massive sort of basement excavation things that they do in Kensington, where they've got these like mega extensions sort of underneath the surface. I don't know if anyone's seen it, but I heard, in fact, I could see that literally a neighbour's house completely crumbled down to the ground because their neighbour was doing one of those mega basements, and it compromised the structure of their land, and it led to you know, the house actually collapsing. So that's an example of a right of support, and that would be described as a negative easement. Okie dokie. All right, so let's move on to the next slide then. Okay, so we're now looking at, so we've looked at the characteristics of an easement, and we're now going to look at or think about how these easements can be created. And I guess the starting point for whenever you're analysing a claim for easement is to, as I said before, so when you're doing your exam, if this comes up, you would always set out the test under re Ellenborough. So you would always look at those four criteria that we've just talked about. And then if the right claim does fall, you know, if there is a right, then it's great. If it meets all four of the criteria, then that's fantastic. However, if it doesn't meet one of those criteria that we mentioned before, so let's go back just to remind you, how far back do I need to go? If one of these are not satisfied, then let's have a look. Let's go back to the main. If one of these essential characteristics are not satisfied, then it's not going to be an easement. It wouldn't be classed as being an easement, and so the person trying to claim that right, they will be denied it essentially. However, if it does meet all of these four criteria set under re Ellenborough, the next step is just to consider how that easement was created, which is what we're looking at now. And you'll see from the slide that there's three main ways or three ways of creating an easement. And just reading off the slide here, that's an express grant or reservation, an implied grant or reservation on the sale of a part, or by way of prescription. So we'll just have a look at each of those in turn so that we can be comfortable knowing that we know which, you know, how to do each one of those. So let's have a look at expressed grants or reservation. Okay, an expressed easement is where an owner of two neighbouring pieces of land agree that one of them should have an easement over the other person's land. Okay, so this is usually done or commonly done where there's been a sale of part, but it can also be done or created at sort of any time independent of sort of any sale. So if we just flick to page, I know the pages are not numbered, but I number my pages. Page 5 of your student guide where it's headed, it's 3. It's got how to, easements are created. And you'll see that there's 2 examples of expressly created easements, and these are headed example A and example B. So I'm just going to give you a couple of minutes to read through example A. And I just want to, you to let me know if I set up another poll. Actually, it might be easier that way. Tell me what you think about example A. I don't think you can do this by poll. Okay, so example A says the transferor grants for the benefit of the property a right for the transferee in common with the transferor and all other authorised persons, or by way at all times and for all reasonable purposes, and the vehicles where appropriate over the roads, footpaths now constructed on the estate. So what does that mean? So hopefully you would have noted that the person selling the land is granting sort of an easement to the person that's buying the land. Okay, have a look at example B. Give you a couple of minutes to read through that and have a think about what you think it's trying to achieve. All right. What do we think this one's trying to achieve then? So it says the transferor accepts and reserves out of the property for the benefit of the remainder of the estate the right of the transferor, the owner of the other plots on the estate, and all other authorised persons to use water, soil and gas pipes and other electricity and telephone cables now laid under the property and which serves the other parts of the estate. So what's that saying? What does all that mean? Hopefully, when you're reading through example B, you would have picked up that the person selling the land this time is reserving or holding back easements. Not so. So remember, negative is just a negative easement is more. Just think of it as a right of support, so that you know you're sort of stopping your neighbour from building something on their property or digging their foundations, so that you know it doesn't. You don't want it to have a negative effect on your property. So it's to protect your properties, to support your structure so it doesn't collapse. Example B is more of a reservation. So it's the person that's selling the land, what they're doing, they're holding back or reserving an easement out of the land so that they can sort of enjoy an easement. When you compare that with the first example, the person selling the land was granting or giving an easement to the person that was buying the land. Is that okay? Okay. So example B, was the person that was selling. Example B, the person that was selling their land, part of their land, was holding back or reserving, what's known as reserving an easement so that they could still walk over or do something over someone else's land. But when you compare that with example A, they were actually given an easement, so they were giving the buyer a right over the land. Natalia, is that okay? It's these two different words, so sometimes you have to look at whether these will be positive easements. These are positive ones. Both of them were positive easements, but one was granting, one was giving the right to the buyer, and the other one was reserving or keeping the right for the seller. That's the difference between those two. Is that okay? Is that right, Natalia? It's just getting used to the different terminology of granting and reservation and what that means. Okay, all right. So let's look at what it means to be a legal, what it means to be a legal easement. So the right must be granted in one of two ways. If I take anybody in this in the workshop, what I always say is that the two types of legal easement could be a forever easement or one for a fixed period. So the legal terminology to describe a forever easement, if you ever see the word fee simple, that just means, yeah, absolutely. It means that it's almost like being a freehold. So it's just something that's forever. If it's for a fixed period, it's a little bit like a lease. It's for a term, a defined time. Yeah, fee simple spelled a little bit different. So I just, but well done. Okay, that's how they spell fee simple. Okay, so this is all defined in section 1, subsection 2, subsection A of the LPA 1925, and that defines really what makes a legal easement. So a legal expressed easement must be created by deed, and that's supported in section 52 of the LPA 1925. So providing all the correct formalities have been made, you've got this legal expressed easement. So documents, it should describe itself as being a deed. It should be correctly signed. It needs to be witnessed and they say delivered. So section 1 of the LPMPA 1989. If the land is registered, there's also an additional requirement to ensure that the easement is registered on both titles. So it needs to be registered on the title that has the benefit of the easement, but also on the title of the land that has the burden of the easement. Just please note, with regards to easements, there's no such thing as an oral or verbal or parole sort of easement. Any attempt to create an oral easement, all they'd be creating is a license. So you can't have, unlike a lease where you can have a parole lease, which just essentially just means an oral lease or a more informal one. There's no such thing for an easement. You can't have an oral easement. Okay, let's move on to the next slide. Okay, so this slide's headed implied grant or implied reservation on a sale of part. So if an easement hasn't been created expressly, as we've just talked about, if it's not in a deed, hasn't been written, if it's not a legal expressed easement, it can be created by other means. And so one of those means is implied by implication. There is another one by prescription, but we'll look at that in a moment. So when it's been, when you have an implied lease, this might or usually occurs where there's been a sale of part of the land, and I guess it depends on certain circumstances. An easement might arise in that situation. Just note that easements created by implication, they're binding on successors of both the dominant and the servient tenement or the servient land. So let's have a look in greater detail how this might happen, how this might arise. I guess essentially, when you see, it's like this easement can be created automatically on a sale of part, even though there was no sort of express provisions made for the easement. It could happen on a grant of a lease of part, or implied easements are sort of illegal easements as they are implied into a transfer of a legal estate when the part of the land is sold. There are different rules depending on whether you're a seller or a buyer. So if you're a seller, there's two types of implied easements that are available to them. And these are strict necessity and common intention. So these easements will be impliedly, would this be uploaded at the end? Let's have a look at your in your student guide. So if you look at, I've numbered my guide, we're on page 7. Timmy, yes, Timmy, it gets uploaded. Thank you. Okay, so there's 2 implied easements available for a seller. One's of strict necessity, the other is of common intention. So the easements will be implied, so it'd be reserved or held back. Remember, we talked about the difference between granting and reservation or holding back. So it's held back out of the land being sold for the benefit of the land that the seller's retaining, the seller's land, the seller's land that they're keeping. Buyers have 4 types of easements available to them. These are strict necessity as is available for the seller. Common intention, again, as it is available for the seller, but they've got 2 extra ones. So they've got easements under Wilson v Burroughs, which is a case 1879, and easements under section 62 of the LPA 1925. So we'll look at these 4 different types of implied grant or reservation in a moment. So we'll just take each one in turn. Strict necessity, I think, is quite an easy one to think about in terms of it's available. I mean, as I've sort of mentioned, it's available both for the seller and for the buyer. And the courts, they recognise an easement if there hasn't been an express grant, for example, given, but you would absolutely need it because without it, you wouldn't be able to use the land at all. So just think about a plot of land. If that land was completely landlocked, then they wouldn't be able to access it unless they trespass. And so because of that, the courts would recognise that you know, you need to have an easement over another land in order to access that plot of land. They looked at this in detail in the case of Wong v Beaumont Trust, which is there in your student guide under heading. Does somebody want to say something? Someone's unmuted. Okay, so in Wong v Beaumont Property Trust Limited 1965, so you will cover this in your reading, but it's a good example. The important point to note is that the test of necessity is a strict test, so strict necessity there. So you strictly need to have this easement, otherwise, you just couldn't use your land properly. Second test there is common intention. So this is available for both seller and the buyer. And this is where parties they either sell or lease or had of part, and they intended the land to be used in a particular way. And that easement was required to enable it to be used for that way. They're implied. When does this rule apply, I guess? I think it's important sort of to understand the difference between it is the intended use of the land that gives rise to the common intention and not the other way around. So it's not the common intention to create an easement. So that's a concept that you need to look at closely when thinking about applying sort of common intention as an implied easement. So Natalia, what they're looking at in terms of the rule for common intention, it's the intended use of the land that gives rise to the common intention. That's what causes the common intention. It's not that parties had intended to create an easement. Do you see the difference between that? Yeah. Okay. All right. So now we're going to have a look at Wilden and Burrows and Section 62. So these two options are only available for the buyer. The sellers couldn't rely on Wilden and Burrows or Section 62. So we'll look at Wilden and Burrows first. Old case 1879. Under Wilden and Burrows, the buyer of part sort of gets an implied easement over the seller's land if the right means that the right basically has to meet these three conditions. Okay, so the three conditions are: the easement must be both continuous and apparent. You'll see that at the bottom of your student guide. So under F, numeral points 1, 2, and 3 has to be continuous and apparent. Necessity for the reasonable enjoyment of the property, and being of quasi easement, or like I sort of say, fake easement by the seller for the benefit of the land being sold at the time of the sale of part. So we'll look at those conditions in detail now, because I think it's quite important to understand what it means when they say continuous and apparent, etc. So what does it mean by continuous and apparent? I guess it means that there must be some sort of feature on the servient tenement that would be apparent or obvious when you inspected the property. Might be a worn path that you can sort of, it might be more than that, probably like just say there was a drain and a manhole cover on a path. That would be an example of a feature that is continuous and apparent. And there should be this degree of permanence as well. Okay. The next one with that, they say that it should be necessary for the reasonable enjoyment of the land. And I guess that really means it's not like before when we were talking about strict necessity. This is a lesser, it's not as strict as that. So it means that the right should facilitate the reasonable enjoyment of the property. It's not a strict test like the easement of necessity. And then the third one, it says that it should be used as a quasi easement, and I just say a quasi easement is like a fake easement. So this is where there's a right being used over one part of a person's land for the benefit of the other person's land. That would have been an easement if those two parts of land were in separate ownership. So I think the best way is to go back to our slide that we were looking at the beginning. So just say these two houses were owned for some reason by the same person. So we've got 63 and 65 Hampstead Road. If one person owns both of these properties, and let's say they physically live at 65, and the drain from 65 runs across the back of the garden to the back of like 63 down the sewer to the main road. If the owner decides then to live at 63 instead, and he sells 65, the buyer of 65 will get the drainage right under Wilden and Burrows. Can you see? So, you know, before these two plots were owned by the same owner, and in some respect it created this quasi easement, because you can't have an easement if there's not two separate owners of the land. But when they do split the land up and sell it to somebody else, then it creates this you know, we can rely on Wilden and Burrows in that scenario. Okay. All right, so let's have a look now at section 62. What do they mean by section 62? Again, this only applies, it's only available for a buyer of part, not for a seller. Section 62, essentially what it does is to imply the general words into a conveyance of land, which enables the right of a permanent nature that already exists at the time of the sale of part to be passed automatically to the buyer. And I think the idea behind section 62 was to shorten documents and therefore reduce costs. So what section 62 has the power to do is just to convert, for example, a mere license into an easement. The main authority for this, if you turn over on your student guide, I think you probably want to note this somewhere, is the case of Wright v. McAdam, 1949. And in that case, in Wright v. McAdam, I'm going to write this down for you because it's not in your student guide. Wright v. McAdam, 1949. Okay. So in that case here, there was a license to use what was a coal shed, and then it was converted into an easement when the tenant was granted a new tenancy. So have a look at that case after the session, just by way of consolidation, because it's one of those sort of an authoritative case that you can use in an exam question. Okay. All right, so just moving on to the next activity. Has the power to convert a mere license into an easement? Absolutely, Natalia. So if someone has a license to use something, so in that particular case there was a license to use a coal shed. I guess you guys don't even know what a coal shed is now, because most people have central heating, not the need for sort of storing coal in the garden in order for the fireplace. So someone had a license to travel over their, I think it's the landlord's garden, in order to store the coal and to retrieve the coal. And then when the landlord granted a lease, a new lease, he didn't want her to use it unless she paid money in order to gain access to that coal shed. But then it was said, actually, you know, just relying on section 62, that license had converted into an easement. Does that make sense, Natalia, before we move on? Yeah. Have a look at the case after in greater detail as well, because it is, like I say, it's a good authority for relying on section 62. Okay, so now next activity. Activity 2, how are we going to run this? Okay, so activity 2 is asking you to help, just basically it's trying to help you understand implied easements, how it's created on a sale of part. And I guess it's just to reinforce your understanding of how easements can be implied on a sale of part, and how sort of the different rules apply to the buyer and seller. So in a moment, I guess you can read through the scenario given in the MCQ questions, and then I will set up a poll for you to the same one that's in your student guide. So when you're looking at what I number as being page 9, we'll try to answer those questions in a moment using a poll here. So looking at this plan that we've got on the slide here, essentially what we've got is Letitia. She owns this freehold of this whole property shown on this slide. And she originally grants a lease of the annex to somebody called Trent, and she gives him a right of way over the yard, but no other rights. Trent found this inconvenient, however, especially when it was raining, bad weather, things like that. And so Letitia said that she told him that he can use this hallway of the main building to get into the annex. Trent's lease recently expires, and it says here that Letitia has granted him a new lease with the same rights over the yard, but there's no mention of him being able to use the hallway or the hall. So reread through this question in your student guide if necessary, and then I just want you to select one correct statement out of the 4 options. So I'll just set up this poll while you guys are reading through that question again. Okay, I've just set up the poll. Hopefully you've had enough time to consider those options. T stands for Trent. It just doesn't allow me to write too much within the choices there. Okay, got some votes coming through. So the options are T can use the hall despite it not being in the new lease, as he has an oral easement. Remember what we said about oral easements. Second option is Trent has nothing in writing in relation to the hallway, so he cannot use it at all. Or T has acquired an implied easement under Walden and Burrows, as the lease qualifies as a sale of part. Or the last option is T has an implied easement, section 62, as he used the hallway at the time the lease was granted. I'll give you a couple more minutes before so I think the approach would be to go through each of the options and think about whether the criteria has been made. Remember, in Wilden v Burrows, it has to be continuous and apparent and necessary for the enjoyment. And what was the last one for Wilden and Burrows? Can we remember? It's got 3 conditions, hasn't it? And then they talk about that quasi easement. And then section 62, that's similar to the McAdam case that I put in the chat, where somebody was using that coal shed under a license and then it converted into an easement. Okay, I'll stop it there because we're not sure, I think, but the majority, the small majority of people that voted answered, so the last option's right. It's the classic section sort of 62. The renewal of the lease counts as a conveyance under section 62. So the access through the hallway of the main building is essentially like a privilege. And then at the time of the grant of the second lease, the main building and the annex are in separate occupations. And so the effect of section 62 was to convert the privilege being enjoyed by Trent into an easement. So it's just like the case of McAdam. There's no sort of requirement for it to be continuous and apparent and necessary for the reasonable enjoyment. So it's likely that it's going to succeed under section 62. The first option was incorrect simply because the easement, you can't create easements orally. Remember we said there's no such thing as an oral easement. And the other option was wrong. Let me just put that there again. I'm not asking you to vote. I'm just trying allowing you to see what I'm talking about here. This one was incorrect because he will have an implied easement right despite there nothing, it doesn't matter that there's nothing in writing. You can still have an implied easement. Okay. All right, so just moving on to the next slide now. So we've looked at easements created by implication. We've looked at, before that, easements created expressly. And now we're going to consider what we mean by easements created by prescription. Before you consider what type of prescriptive easement we're likely to rely on, what you have to do is consider what's known as these common law conditions. So if you look at what I call page 9 of your student guide, under section, it should be section 3.3. So sort of midway down where it's headed prescription. So you'll see from the student guide in section A that there's space for you to sort of write further details or type in further details. So I'll speak slowly to enable you to insert the additional information. So essentially an easement may be created through what they say is long use. And it says in the student guide, it's one where the owner of the servient land has acquiescence. Another word that we need to look at then. So what does that mean? What does acquiescence mean? I would describe that as meaning that the owner of the servient land both knows of the use, and although he knew about it and he had the power to stop it, he does not do so. So he knows that somebody's using a piece of land. He knows he has the power to stop it, and he doesn't stop them from using it. Okay. So an easement by prescription, it doesn't need to involve, like we were talking about implication, it doesn't need to involve a sale of part. It doesn't need to be expressed or be an implied grant or reservation. So you can claim it in three ways. So you've got these common law prescription, and you've got the doctrine of lost modern grant. Sometimes you might see it being referred to as LMG, or under the Prescription Act, which is an old act of 1832. So those are the three main ways that you can have easement by prescription. But before you consider any of those, you have to look at those common law conditions that are described there. So user as of right, freeholder, and then continuous use. So let's look at what it means when it says in that first light blue bullet point, user as of right. What does that mean? A bit of Latin here, should you be interested. I might type it in, I'll type it in the chat. So they say nec vi, which means without force. So I'll just write that. Without force. And then you've got nec, oops, nec clam. I'm not sure whether I'm saying this correctly, but exercise without secrecy. Any secrecy. And then the last one, you've got nec precario, and that means without permission. Okay, so when it says it must be a user as of right, it means that you must be using it as of right without force, without secretly sort of using it and no one knows about it that you're doing that. And if somebody gives you permission, then that will not suffice in terms of those common law conditions. If someone said, oh, you're allowed to do this, that's not quite the same. That sounds a little bit like an oral easement, which is, as you know, it would be a license. So you have to be doing this without force, without secrecy, and without permission. Second part of the comment, so it's in the light blue bullet point there, freeholder. So what does that mean, freehold owners? The user must be by freehold owners against another freehold owner. And the last part there, it says continuous use. So it must be continuously being used throughout the required period. So where the common law conditions apply, a claim can be defeated by showing that there's been some sort of written or oral consent, if that has been given to enable someone to exercise a right. Okay, so let's examine now the method of creation. So those the following three light bullet points there, where it's got common law prescription, doctrine of lost modern grant, and prescription act. Let's look at common law prescription first then, so it comes first in the list. Okay, so everyone steady on here, because you're going to really have to use your imagination, I think, to get this concept firmly in your mind. So with common law prescription, it's based on this presumption that a right was granted and it's been in existence, it's been basically exercised since time immemorial. And they say that the date of time immemorial is 1189. So it's a really strange one, because the courts will presume that if the user has been exercising, for example, a right of way for 20 years, let's say, if it's been continuous for those 20 years, they would say that basically then they make this presumption that they've been doing so since 1189, which is time immemorial. So just because someone's been using something or doing something for 20 years, the courts make this far-fetched presumption. So this type of easement, as you can imagine, is sort of rarely used now because it's only a presumption which in some respects can be sort of easily rebutted if you can show that the right has could have sort of arisen, I guess, after this 1189 period. You think about London, you know, if you're trying to say that you've been using this pathway, for example, and you've been doing this for 20 years, trying to rely on common law prescription would be difficult because it'd be easy to show that maybe, you know, the property was only, or the pathway or the area was only built, let's say 100 years ago. You know, the house is only 100 years old, so quite on it, obviously they haven't been using it since 1189. So it's easily, that presumption is easy to rebut. Although I think somebody in one of my workshops was saying that the Houses of Parliament was built at some sort of period which maybe was sort of before that 1189 time. Time immemorial. They say, I'm just going to write the year. They say that if you've been using, I'll use the example of a right of way for 20 years, under common law, they say that there's a presumption that you've been using it for time immemorial, and I write that word as well, time immemorial. You've been using it for time immemorial, and time immemorial, they date that back to the year 1189. So it's quite a stretch, it's quite a reach, isn't it, to make that presumption just because somebody has been using something for 20 years to say, well, if you've been using it for 20 years, then you've been using it since 1189. But it's only a presumption, and that presumption is easily rebutted because if you can show that they couldn't have possibly been using it since 1189 because, for example, you know, the structure or the building or the path was only created 50 years ago, let's say, so that new development was only created 50 years ago, then that breaks or rebuts that presumption that it's been in use since 1189. Is that okay, Lana? It is a reach. Yeah, I did say steady on. All right, then. So we go from the strange to the ridiculous now. So we've looked at the common law presumption, and now we're going to consider the doctrine of lost modern grant, which is also, you have to use your imagination here to try to sort of rely on this one. If you thought the common law prescription one was sort of far-fetched, and this one's even worse. So the doctrine of lost modern grant, or LMG, it's purely fictional. So essentially they say if the user's been, if they've been doing this for, you know, 20 years, they assume, okay, that there must have been a deed granted, which granted this right, but that deed has been lost. They've completely just made this up. So they assume that just because you've been using something for 20 years, that actually there must have been a deed and that deed has been lost. Purely fictional. Okay, but it's still a very sort of popular claim, particularly where there's been sort of a 20-year user and then there's been a break in use at, you know, sort of some point after. So it's important because once an easement has been acquired under any of the two that I've just mentioned, it essentially exists forever, and it doesn't matter if that right is subsequently, if it falls into disuse. Okay, so we've got this common law and we've got this doctrine of lost modern grant. Okay. All right, so now let's have a look at the Prescription Act of 1832. So you can see on the slide that there's three main sections that we rely on. one of them deals with non-light easements, the other one deals with light easements. So I think possibly it might be considered as being a more complicated method. And like I say, you know, they have this distinction between the right of light and then all other easements. So let's start off with the non-light easement. This is dealt with under section 2. Don't worry at this stage, I would say, about the ins and outs of this. I just want you to have a basic understanding of this for now. So under section 62, a claim for a non-light easement can be used based on this 20 years period of use or a 40-year period of use. In either case, the period must be immediately before an application to court. So if a claim is based on 20 years use, all of the common law conditions must be complied with. If it's based on the 40 years use, then the Act states that the right shall be deemed absolute and indefeasible, unless it's enjoyed by a written consent. And what this seems to mean is that there's no need to prove common law conditions in those circumstances. Okay, so those are non-light easement. And then section 3 covers the right of light easement. If you wish to see the actual act itself, just note that I think it's at the back of, it should be at the back of your appendix section of the student guide. You should note that it's easier to acquire a right of light easement by prescription than any other sort of easement. So all the user has to do is to show that they've used the right without interruption, and it will become an absolute and indefeasible just after 20 years. It does not have to be as of right, and only written consent at any time can defeat it. So for both types of easements, you know, the 20 and 40 year period, it must be without interruption and before some suit or action. So that's section 4 there. So that means that there must be a court action to claim the easement, and the 20 or 40 years must be continuous up to the date of that court action. Take a look at section 4 in the appendix. So it states that there can be an interruption in the use. So as long as it's not gone on for over a year with the person that uses the right knowing about the interruption and submitting to it. So you can have an interruption there just as long as it's not over a year. When I say interruption, it's essentially meaning that, you know, you haven't been exercising or using that prescriptive easement. Okay. Okay, all right. Let's have a look now at enforceability. So I've just moved on to our next slide here. So when a dominant land is sold after the creation of an easement, you see from those bullet points that the benefit of the easement passes automatically to the new owner under section 62 of the LPA 1925, sort of like a word saving effect. Where the servient land is sold, whether it's enforceable against the new owner depends on how the easement was created. and also whether the easement is legal or equitable. Okay. So let's look at registered land. So if a land is registered, the easement is legal and created by expressed grant or reservation, but it must be registered. You would see evidence of this easement in the charges register. So do you remember when we looked at what registered title looks like? It's split up into those three sections. You've got the property, the proprietorship, and the charges register. So if there was an easement, it would appear in that last section there in the charges register of the title to the servient land. But it would also appear in the property register for the dominant land. So it appears in different ones depending on whether it's the dominant or servient land. Legal easements that are implied or by prescription or prescriptive, these are overriding interests, our friend overriding interest again. So it falls under Schedule 3, paragraph 3. So if you look at the top page of page 12 in your student guide, where it says that they will be binding on a new owner of the servient land if they would have been obvious on the reasonable, careful inspection of the land, or the servient owner knew about them, or the person claiming them can prove they exercised the right in the year prior to the sale. That's at the, what I call page 12 of your student guide. Okay. We've got another exercise coming up, but before we look at that, so we've talked about the registered land. If the property was an unregistered property, remember there's about 13% of properties still in England and Wales that they say is currently still unregistered. So if the property is unregistered, a legal easement, including one created by implication or by prescription, will bind the new owner irrespective of notice. Okay, so they bind the world. All right, so we're now going to look at this activity 3, which is midway down page 12 of your student guide. It's just another MCQ. I think they're really trying to build up your appetite here for being able to deal with multiple choice questions. I'm not going to be able to fit this very big question in a poll. So I might just ask you to vote A, B, C, or D. I'll just read it out. So we've got somebody called, I'm just reading just at the bottom of activity 3 there, where it says that Helen is the registered owner of property used as a riding stable and sold it last week to Neil. The transfer deed made no mention of the property being subject to any easement. However, several months before the sale, Helen granted by deed to her neighbour Alex a drainage easement for forever across part of the property. At the same time, she sold to another neighbour, Lucy, part of the property which had a garage built upon it. Unfortunately, in the transfer of land to Lucy, no mention was made of the easement, and Lucy cannot gain access to the garage except by crossing a part of a driveway to the stables, which she's been doing ever since the sale. Neil's just discovered that Alex and Lucy are claiming rights over his property, and what I'm asking you to do here is just to choose option A, B, or C, or D, because I don't think I'm going to be able to write that question in the actual poll itself. So have a read through that question again, and then if you can just vote once you've made a decision. I say, it's important to have a go at trying to build up a technique for MCQs, because what I found looking at the last assessments are some people if they do really well in their MCQs, they've already got that 40%, and if they make a mistake for the written part, it's pretty difficult for them to fail because they've already in effect done well with the MCQs. So it's really good to practice that skill. Okay, I'll read out the question again, and then if you can just make a decision as to whether it's A, B, C, or D. So you've got Helen's the registered proprietor of a property used as a riding stable, sold it last week to Neil. The transfer deed made no mention of the property being subject to an easement, or for several months before the sale, Helen granted by deed to her neighbour Alex a drainage easement forever across part of the property. At the same time, she sold she sold to another neighbour, Lucy, a part of the property which had a garage built on it. Unfortunately, the transfer of the land to Lucy didn't mention any easement was made, and Lucy cannot gain access to the garage except by crossing a part of the driveway to the stables, which she's been doing ever since the sale. And Neil's just discovered that Alex and Lucy are claiming rights over his property. And then there's 4 options here. A, Helen had granted Alex a legal easement. As a result, it's automatically binding on Neil. Option B, Helen had granted Alex a legal easement. As a result, it is binding on Neil if the easement was registered against her title. Option C, Lucy can claim an implied easement, but only through common intention or strict necessity. And the last option D, Lucy can claim an implied easement, and this will be an equitable easement interest binding as an overriding interest under Schedule 3, Paragraph 2, LRA 2002, as long as it would have been obvious to Neil on the reasonable, careful inspection of land, or Neil actually knew about it, or Lucy can prove that she exercised the right in the year period prior to the sale to Neil. Is this a really tricky question? So you've had 5 minutes. You wouldn't have 5 minutes per MCQ in the real exam. So we'll just run through the answer on this one. Okay. The correct option would have been option B. And the reason being is that it's a legal easement expressly granted. So it must be registered, as it says there, in order to sort of take effect and bind future buyers of the servient land. Statement A, let me put it up so you just to, actually you have to look in the student guide because I wasn't able to write the whole of those options. Statement A was incorrect, therefore, because it's talking about it's the complete opposite, isn't it? Statement C is obviously incorrect, as it's not clear whether Lucy would be able to claim an easement of necessity. It would depend on whether the right is essential for her to be able to enjoy the land. So remember we said that it's quite, you know, we don't have information from looking at the facts above. She might be able to rely on Wilden and Burrows if Helen's using the drive to access the garage as what we call a quasi-easement. And she may even be able to use section 62 if using the garage was continuous and apparent. Statement D is obviously incorrect as well, because although Lucy may be able to claim an implied easement, it will not be legal. It will be legal and not equitable, because I think in that question it was saying that it would be an equitable one, and it wouldn't. It would be legal, and it would be overriding under Schedule 3. Remember we talked about this before. Schedule 3, paragraph 3, LRA. So just some people make the mistake actually of talking about Schedule 3, paragraph 2. Remember that the paragraph 2 is really to do with actual occupation. Do you remember when we talked about that in when we were discussing in detail third party right? So with an easement, it would be paragraph 3, not paragraph 2. So I just thought I'd just dispel sort of any myths there with regards to that. Have a look at that MCQ in your own time after the session. Maybe you might need more time to sort of read it quietly or privately on your own. So let's have a look at I think that's it in terms of slides. If you turn the next page on your page, what I say is page 13 in your student guide, paragraph 5, where I'm just going to read this out actually. The strategy for answering a problem question on easements. So when you have your workshops on this session, when we talk about easements, how we usually run the workshop is to ask you to draw a diagram, a bit like how we were. Let's go back to what we'd usually, not a complicated diagram, but what we might ask you to do is just to draw a diagram to represent the pieces of land involved. You know, I'm just reading point 1 here. The owner's change of ownership and the dates, just to clarify the facts, because sometimes, as you've seen from that last MCQ question that we were looking at, sometimes there's quite a lot of facts to manage, and it can be quite helpful just to do a diagram to explain what's gone on here. So for each possible easement, I'm reading point 2 now. Identify whether the right being claimed is capable of being an easement. And do you remember when we were looking at the Re Ellenborough Park characteristics? So the essential characteristics of an easement is defined in the case of Re Ellenborough Park. That's these 4 points here. Is there a dominant servant tenement? Does the easement accommodate the dominant tenement? Are the dominant and servient tenement owned by separate people? And is the land capable of forming the subject matter of a grant? So those are the 4 criteria there. So you would run through that first. Once you discovered that there is a possibility of an easement, the next thing to consider is, well, what type of easement? What type of easement have you got? Is it one that's been created expressly? So do you remember when we looked at express easements? It's these 3, isn't it? Does it meet these express legal easements here? Is it done by deed? Section 1 LPMPA, Section 52 LPA? With all the correct formalities, if it was a registered land, was it registered under both titles? And if it wasn't an expressed easement, how else could it have been created? Was it by implication or by prescription? So remember, implication is quite a wide subject. Remember, we've said that sellers have 2 options for reservations, the strict necessity and common intention. However, as a buyer, they've got the 4 different ways by implication. It could be strict necessity, common intention, what's known as under Wealden and Burrows or Section 62. So once you've described or made a decision as to whether it's an expressed, implied or prescriptive easement, you may then have to look at point 4. So if the dominant land has been sold since the easement's been created, you might want to apply Section 62 to show that the benefit has passed to the new owner. And then lastly, point 5, if the servient land has been sold since the easement has been created, you need to decide whether the new owner is bound by the easement or not. And then you to do that, you just need to work out whether it's legal or equitable, or whether as it says here, whether the title to the servient land is registered or unregistered. So this, I mean, I would highlight this because this is your structure. These are the structure. That's the structure that you would use to answer any sort of question in a written exam to do with easements. So when it says to draw a diagram, you're not marked on any diagram. That's just for your own purposes, just to see whether you completely understand the facts as to what's going on. It's just a quick reference for your own purposes. It's not something that you submit. And then you go through the 4 criteria under re Ellenborough Park. Then you look at how it was created, expressed, implied, or by prescription. And then depending on that, you look at points 4 and 5. Okay. So that's how you would approach a problem question in the exam. And now I guess we'll just summarize. It's pretty much actually what it says here in where it's got the key facts on pages 13 and 14. So again, I'll just read from the student guide here because I think it's quite concise. It says an easement is a right attached to one piece of land that burdens another piece of land. So that's what an easement is. And remember, an easement, you need to make sure that it's an easement and it's different. It's not the same thing as a license or a lease. And remember, we can't have an oral easement, no such thing. If there's any evidence of somebody trying to rely on an oral easement, they probably say it's a license. Okay. Easements, as it says, it can be created in either expressly by implication or by prescription. Just note, be clear that implied easements, these are legal as well. They are legal. However, it doesn't matter what type of easement you've got, all of them, if it's an easement, it has to have the 4 characteristics described in the key case of Ellenborough Park. If you're trying to rely on an expressed legal easement, in order for it to be binding, it must be registered. And remember, implied easements, these are known as overriding interests under Schedule 3, Paragraph 3, LRA. Okay. So I think you are doing mocks, I think, coming up soon. So workshops 5A and 5B will just give you an opportunity, I would say. Let me just put the code, the first page for the code on the screen. When you attend workshops 5A, I think I was saying, and 5B, it just gives you the opportunity, I think, just to apply your knowledge in greater detail of easements, because it is a fun subject, but it is there is a procedural way, a set procedure for dealing with easement questions. And just, be clear with that key case before you can even talk about any easement. You must talk about Re Ellenborough first, has to have the characteristics of an easement. So it has to meet those 4 key characteristics. And if it does, then you consider, like I say, what type of easement is it? Is it expressed by implication or by prescription? And you would follow that through. And then if it's either of those, just make sure that obviously it's enforceable as well, because if it's an express legal easement, it should be registered, for example. Okay, so that marks the end of this week's large group. If there's any questions, if you want to put that in the chat, I'll be here for about 5 minutes or so. Okay, thank you, goodbye.